Thanks, Concorda. Minister, I wanted to pick you up on a few things that you said at the committee stage when we were debating these amendments. For example, Minister, you said, and I quote you, "Imagine a situation where a driver would not give his or her consent to have penalty points information shared between one arm of the state and another." You also mentioned that a person who is not tax compliant would be empowered not to give consent to the sharing of his or her data between the agencies of the state based on our amendments. Both of these examples, Minister, reveal a fundamental misunderstanding of basic data protection law. You presume that consent is always required. That's not true. Article 6 of the GDPR, for example, lists various exceptions to the consent requirement. One such exception is processing that is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. Processing data in relation to taxation clearly has a legal public interest basis. Section 60 of our own Data Protection Act in relation to public interest processing lays this out very clearly. It permits data processing without consent of the data subject, and I quote, "for the prevention, detection, investigation and prosecution of criminal offences and the execution of criminal penalties, and for the administration of any tax, duty or other money due or owing to the state or a local authority." This is from our own Data Protection Act. Raising the issue of consent in relation to penalty points is bogus, Minister. With responsibility for such a massive data sharing project, I don't think you should be going down this road. The Data Protection Act also transposes the Law Enforcement Directive, which applies instead of the GDPR in relation to the processing of personal data carried out for a law enforcement purpose. So the idea that someone might withhold their consent to data sharing in order to avoid arrest or prosecution is clearly not possible. In fact, it's nonsense. Amendments number 6 and 9 are intended to address the issue of processing for reasons other than the reason for which data is collected. The Public Services Card registration is only one point of data collection for the purpose of this bill. The bill clearly applies to many other instances of data collection, which we are not addressing with Amendment 5, and with lines 23 to 25 on page 10 and lines 25 to 27 on page 32, which the Minister's amendments numbers 4 and 10 are seeking to delete. This bill seeks to make state entities able to access a citizen's personal data which was given for one specified purpose for a new purpose. This is not legal, based on the GDPR and the Barra judgment for that matter. Our amendments create an opt-out option. They do not require that a person be asked if they consent. I appreciate that the amendments would create difficulties for the Department, but if the Department is not administratively ready to implement the bill in compliance with the GDPR and EU case law, then the Minister shouldn't be trying to bring the bill through the House until the Department is actually ready. These amendments build on and make meaningful the Minister's own amendments in the Channel so that disclosure of data is not possible simply to avoid a financial burden on a public body, but instead is permitted to avoid a financial burden on a person or data subject. Under the GDPR, consent, when it is required, and it is not always required, it must be informed and it must be specific. Data must be collected for a single specified, explicit and lawful purpose. Recital 32 of the GDPR explains this clearly. Consent should cover all processing activities carried out for the same purpose or purposes. When the processing has multiple purposes, consent should be given for all of them. The data sharing agreements the bill proposes are positive, and just to be clear, the personal access portal is certainly very positive. But if the type of processing the data sharing agreements propose requires consent, and if this processing or sharing is different in purpose to the initial processing for which the data was collected, then the data sharing agreements won't address the necessity for informed specific consent, and our Amendments 6 and 9 address this. This is a problem. If you have consent for a specific purpose and want to process data for a new purpose, consent needs to be asked for again, as the initial explicitly given consent no longer applies. Obviously, it's a good thing that public services are efficient and that state agencies and public bodies reduce costs. We fully support this idea. Of course we do. But that is a separate argument. The state cannot act illegally, and our amendments are trying to make sure it doesn't. And it's up to the Minister and his department to come up with administrative solutions to deal with our amendments.